Good morning and welcome to today's administrative meeting of the Maryland Public Service Commission. My apologies for getting started a little late this morning. As some of you may encountered in the lobby, we had a fire drill that was not planned or expected. This might just be a good time to remind everybody, due to either events like this or inclement weather for the winter, that if we have any delays to the meetings or cancellations that occur on the fly, we will update our social media accounts, so you could check us out on either Facebook under Maryland Public Service Commission or the Twitter account, which is maintained and updated on a real-time basis. Before we get started today, I'd just like to recognize an employee that has been with us for about 2.5 years, Karen Suckling. Karen, right in the front row there behind the high back seat. She's been here with us since June of 2016. From everything I've heard from her management team in Telecom, Gas, and Water Division, she's been a critical asset to them, assisting on a number of rate cases and other presentations over the past 2 years. She's going to be leaving us to become a database analyst at the Oldfield School up the road in Baltimore County, where she'll be using her knowledge and experience to assist them. And this job, I understand, is a lot closer to where you live, and get to go home a little bit earlier and hopefully spend time with, I know you have a beloved dog named Moose. So thank you, Karen, for your hard work here, and we are very appreciative of everything that you've done for the Commission. That's all I've had. Any other Commissioner opening statements? Commissioner O'Donnell.
Let me also wish Karen fair wind and following seas. You've been a pleasure to work with, so thank you for that. And second, Mr. Chairman, under the guise of on this date in history, in 1845, on this date, the U.S. Naval Academy was established in Annapolis.
Happy birthday. I know we have a few Naval Academy alum working for the PSC, so that's a fun fact. Without further adu, we have minutes to approve from the administrative meeting on October 3rd.
We know it wasn't
September 26th.
Sorry, yeah, we missed a meeting last week.
So that would be 26.
September 26th.
Yeah.
Do I have a motion to approve the minutes?
Yes, Mr. Chairman, I move we approve the minutes from the September 26th administrative meeting.
Is there a second?
Second.
All in favor?
Aye.
The minutes are approved. Madam Secretary, the consent agenda.
Yes, Mr. Chairman. On the consent agenda, we have 3 items. First item is VDL Inc., DBA Global Telecom Brokers, filed on September 24, 2018, requested to tariff its regulated retail services effective November 1st, 2018. The second item is Consolidated Edison Solutions, Inc., filed on June 6, 2018, a notice to withdraw abandoned competitive electricity supplier license. And item number 3 is Elkton Gas Company, filed on August 21, 2018. It's a designated weather station in compliance with COMAR Section 20.310305, effective August 2018 through July 2019.
Seeing no questions, is there a motion?
Yes, Mr. Chairman. For item number 1, I would move that we grant the company's request to de-tariff its regulated retail services. For item number 2, I'd move that we cancel the company's license to operate as an electricity supplier in Maryland. And for item number 3, I'd move that we approve the weather station designation for the purpose of determining when there is an extreme weather period that requires restrictions on natural gas service terminations under COMAR 20.31.03.03 and 20.31.03.04.
Thank you. Is there a second?
Second.
All in favor? Aye. Motion carries. Madam Secretary, the administrative
The
agenda.
first item on the administrative agenda is Shahid M. Minas on behalf of Minas Transportation, Inc., filed on August 9, 2018, a request to form a new Charles County Taxi Cab Association.
And if parties or counsel for any of the docket items are present, please come forward when your item is called. Mr. Albert.
Mr. Chairman, Commissioners, Kenneth Albert on behalf of staff. This item addresses a request by Minas Transportation, which does business as Waldorf Yellow Cab, They're seeking commission approval to act as a taxi cab association in Charles County. Mr. Shahid Minhas, the owner of the company, is here today at the
Sir,
podium.
my name is Shahid Minas, and I am here to answer any question if you have. I don't have any question to ask.
Thank you.
In March 2018, the commission granted Charles County's request to allow the commission to begin the process of authorizing taxi cab companies to operate in Charles County. Dispatch by Waldorf to all areas of Charles County will be provided by equipment that's permitted by the commission. Taxi cab service will be available from 6 a.m. to midnight, 7 days a week. Waldorf has a vehicle maintenance facility in Waldorf. Staff visited the maintenance facility as well as the offices and determined they're satisfactory. Staff also found satisfactory Waldorf's system of record keeping, including complaints, manifests, annual reports, calls for service, complaints, and driver's records. Waldorf's rates are higher than rates in certain other jurisdictions where the commission regulates taxi cabs. However, staff believes that the proposed rates are justified when compared to the jurisdiction within close proximity of Charles County. Also, the proposed rates have been in effect for at least the past 5 years without any apparent negative effect on Waldorf or on customers. Waldorf gave staff information on its drivers, including their criminal history checks. Based on its review, staff has determined that Waldorf will continue to operate as an effective taxi cab association. And there has been extensive conversations, including in person-to-person meetings with Waldorf during this process of reviewing their application. Consequently, staff recommends that the Commission authorize Waldorf to operate as a Charles County Taxi Cab Association, conditional on compliance with all requirements established by the Commission related to driver and vehicle standards within 30 days of Commission approval.
Thank you, Mr. Albert. Mr. Minhas, how many drivers do you have?
I have right now 4 drivers,
Okay.
and I'm trying to hire some more, but it is very hard to hire in that area, especially because it is a small town.
And how large is your fleet?
We have 6 vehicles right now. Before I had 8, but due to the objection of the commission, the 2 vehicles were older model, and I have to remove that. So I have remaining 6 vehicles, and I can add any time, any vehicle when when the drivers is available.
And according to your application, you use cell phones to dispatch your taxis?
Yes, sir.
Okay. I imagine your drivers use hands-free devices?
Yes, sir.
Okay. Just checking. Thank you. Commissioners. Commissioner O'Donnell.
Quick question to staff. There was a second cab company operating there that was mentioned in the background. What is the status of that company? Have they applied? Where are they in Charles County?
Good morning, Commissioner. Yes, they have applied, and they are in the process now. We're waiting on one more item with their application, and then we will be able to move forward with that. So
Okay.
they are definitely online with the process.
Okay.
Oh, I'm sorry, Mark Gorman with the Transportation Division.
Okay, very good. Just a comment, Mr. Chairman, the events, the very tragic events the other day in Schoharie, New York, with a for-hire limousine driver really puts an exclamation point on the important work that the men and women in the Transportation Division do at this agency, and the important role that this commission has in protecting the safety of the riding public. These are not small items. Certainly not in my mind. They're very important items. Commissioner Richard, Commissioner Herman, and myself sit on a panel that hear the appeals of many of these decisions emanating from transportation decisions, and we take that very, very seriously in terms of our obligation to balance the needs of public service and the needs of public safety. So I had to say that because what is done in the Transportation Division in this agency is rather remarkable to me and is not to be discounted. So I had to say that at this point.
That is a timely and important reminder for the work that this commission does, that division in particular, ensuring the riding of the safety of the riding public. So thank you, Mr. Gorman.
Thank you, Chairman and Commissioner.
Add to that also, we have a responsibility with a compact WMATSI, Washington Metropolitan Area Transit Commission, I believe is that what that stands for. And so I think it would be also great to have our staff ensure, as we work with WMATSI, that we have some uniformity. So if a vehicle that may be doing business in Maryland is licensed in one of the other areas, that we ensure that Marylanders are getting the same high level of commitment to safety that we expect. So I'll be working with Wamatsi on that, but I just wanted to make that public, that that's another responsibility we have to ensure that the compact, the DMV area, has these high level, safety standards.
Absolutely, yes, sir.
Can I just ask one question? When you say you became aware of taxi cab companies, is there a more formal process, or is it up to the Charles County taxi cabs to come forward? And is there a responsibility of the county to identify and to enforce, to make sure that a taxi cab that is operating is in fact duly licensed with the commission?
That's a difficult question to answer. I don't know if it's really, the way we became aware of it, from what I know, is that they were identified in the county. And we know the jurisdictions that we regulate, and then when we have our investigators that are out in the general public and they see these the sedans or the carriers or the taxi cab companies, they inquire. And then if through an inquiry they don't recognize the taxi cab company or whether or not it's regulated, then that's how it moves forward. And so I believe that's how it occurred in Charles County, is that we became aware of it in that way, and then we moved forward and realized that they were not being regulated by that jurisdiction. So we requested that occur.
Okay. And then if a taxi cab is operating in Charles County, is it up to us to identify that they're in not legally operating, or is the county responsible for ensuring that only
right now, I guess now that we do
operating?
regulate them, it would be that our responsibility to ensure that if they're identified, that we ensure that they have our authority and they're permitted and authorized to operate.
And who's responsible for identifying?
Anyone. We reached out to the chief of transportation in the county, and they are aware of the situation. They are aware that we are now the regulatory authority, so they have individuals that will keep an eye out, and basically we will trade information to ensure that if there is anyone operating, that we're going to ensure that we regulate them.
Great, thank you.
You're welcome, sir.
And perhaps Mr. Minhas can inform us if there's any competition that's unregulated in Charles County. Drop a dime.
Yeah, there is some, I informed already, and they are trying to control them, as much as they can. But it is, as you know, it is almost in the morning, 2-hour drive. It is very hard for them, even though, to reach on time there. But anyway, they are trying their best to do that, control the other, the people who is driving illegally or something like that. So they are trying to control them very much.
Thank you. Is there a motion?
Yes, Mr. Chairman. Mr. Minhas, thank you for coming today. We appreciate that.
Thank you, ma'am.
Mr. Chairman, I move we approve the request by Minhas Transportation, Inc., TA Waldorf Yellow Cab, to operate a Charles County Taxi Cab Association, including the approval of Charles County taxi cab rates effective September 1st, 2008, contingent upon Waldorf's compliance with all requirements established by the Commission related to offering taxi cab services in the state of Maryland within 30 days of the date of Commission approval.
Yes, ma'am.
Is there a second?
Second.
All in favor?
Aye.
The motion is approved. Thank you.
Thank you, sir.
The next item is Lingo Communications, LLC, Birch Communications of the Northeast, LLC, TNCI Impact, LLC, and Matrix Telecom, LLC, filed on July 24, 2018. Joint application of Lingo Communications, LLC, Birch Communications of the Northeast, LLC, TNCI Impact, LLC, and Matrix Telecom, LLC, for approval of the transfer of indirect control of Matrix Telephone or Telecom, LLC, to Lingo Communications, LLC, and for Matrix Telecom, LLC, and Birch Communications of the Northeast, LLC, to participate in certain financing arrangements.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses a filing by several telecommunication companies that ask the Commission to, one, note or to the extent required, approve the proposed transfer of indirect control of Matrix Telecom to Lingo Communications. And second, approve participation by Matrix and Birch Northeast in financing arrangements in connection with the acquisition. The Commission has authorized Birch to provide telecommunication service in Maryland. The Commission has also authorized Matrix to provide telecommunications service. In the proposed acquisition, Lingo will acquire all membership interests of Impact Acquisition LLC, which is the direct owner of Impact Telecom, which is the direct owner of Matrix. After the acquisition is implemented, Impact Acquisition and its subsidiaries, including Matrix, will be wholly owned by Lingo Management, which is a wholly owned subsidiary of Lingo. As a result, indirect ownership of Matrix will be transferred to Lingo and Lingo Management. The applicants also request authority for Lingo to eliminate Impact Telecom from the chain of ownership, and I'll refer to that as a reorganization. This reorganization will occur after the closing of the acquisition and will result in Matrix becoming a wholly owned direct subsidiary of Impact Acquisition. Because Impact Acquisition is an LLC, the acquisition involves the transfer to Lingo of the membership interests in Impact Acquisition. As a result, the acquisition does not involve the transfer of capital stock. Therefore, the acquisition does not need approval under Public Utilities Article 6101C. The elimination of Impact Telecom from the chain of ownership, that's the reorganization, will convert the direct owner of Matrix to the direct owner of Matrix Lingo Management into the direct owner of Matrix. Because Matrix is an LLC, the reorganization does not involve the transfer of capital stock. Therefore, this reorganization does not require authorization under Public Utilities Article 6101. Staff does believe that the applicants have shown that the acquisition and the reorganization are in the public interest. The last piece of this is the financing. Matrix and Birch Northeast will participate in new financing, and in order to maintain flexibility, they seek authorization for Matrix and Northeast to be a borrower, a co-borrower, or a guarantor. A public service company that's a corporation that operates in Maryland needs approval to assume a liability, but both these companies are LLCs, limited liability companies, not corporations. Hence, approval is not needed, but staff here too thinks that the financing is in the public interest. Therefore, staff recommends that the Commission note the transfer of indirect control of Matrix to Lingo, note the reorganization, and note the participation by Matrix and Birch Northeast in new financing.
Thank you, Mr. Albert. Is there a motion?
Mr. Chairman, I move the Commission note the transfer of indirect control of Matrix Telecom LLC and Lingo Communications LLC, note the reorganization, and note the participation by Matrix Telecom LLC, Birch Communications of the Northeast LLC in financing arrangements.
Thank you. Is there a second?
Second.
All in favor?
Aye.
Aye.
The motion is approved.
The next item is Crown Castle Fiber LLC, Crown Castle NG Atlantic LLC, Fiber Technology LLC, Insight Solutions LLC, Light Tower Fiber Networks 1 LLC, New Path Networks LLC, Senesis LLC, and 24/7 Mid-Atlantic Network LLC, filed on August 15, 2018, a joint application for approval of a pro forma consolidation and the cancellation of certain certificates.
Good morning, Mr. Chairman, Commissioners Lloyd Spivak for the Commission staff. This is a filing by Crown Castle Fiber LLC, Crown Castle NG Atlantic LLC, Fiber Technologies Networks LLC, Insight Solutions LLC, Light Tower Fiber Networks 1 LLC, New Path Networks LLC, Senesis LLC, and 24/7 Mid-Atlantic Network LLC for approval of a pro forma internal consolidation and cancellation of certificates of public convenience and necessity, by which they mean their Maryland operating authority. The companies are all wholly owned indirect subsidiaries of Crown Castle International Corp. Under the proposed transaction, the other 7 named companies are being consolidated into Crown Castle Fiber LLC. Public Utilities Article 6-101C specifies that a public service company may not acquire more than 10% of the capital stock of a public service company operating in Maryland without prior Commission approval, and none of the exceptions to this provision apply except for the LLC status. In general, when the Commission must approve that corporate transaction, it applies a public interest standard to its consideration of the proposed transaction. The company states several public interest considerations as reasons for approval, which can generally be summarized as believing they will be able to operate more efficiently as a single company in place of the existing 8 companies. Staff concurs, considering that the consolidation should enable the companies to eliminate redundancies in their operations. With respect to canceling the operating authority of the 7 operating companies that will be merged into Crown Fiber, staff considers the request premature, since it would require the Commission to revoke the company's operating authority effective on an uncertain future date. Accordingly, staff recommends that the Commission approve the pro forma consolidation and direct the companies to being consolidated into Crown Castle Fiber LLC to file for cancellation of their Maryland operating authorities after the consolidation has been completed.
Thank you. Commissioner Richard.
Yeah, just on the point of the cancellation, when just saying cancel upon the consolidation be sufficient? I'm just trying to understand the reason for making this company come back a second time, file 17 copies, and go through this process one more time. It doesn't seem like there's that much consequence to just getting this done.
It's simply a matter the Commission just does not know when that is going to happen, and what actually happens may be something different than what they're actually asking for now. So it was really an abundance of caution that prompted that recommendation.
But they just want to consolidate, isn't that?
That's correct.
So upon
Once they
so
are
just saying upon
consolidated,
consolidation, the staff doesn't believe would be sufficient to meet this concern.
it probably would be, but it would still leave us more comfortable if we knew when it was going to happen and that the companies were in fact no longer operating in Maryland, and they didn't provide that information at this point.
Okay, and I guess the company is not here to answer, so, all right, thank you.
Is there a motion?
Yes, Mr. Chairman. I move for item number 6, we approve the pro forma consolidation and direct the companies being consolidated into Crown Castle Fiber LLC for cancellation of their Maryland operating authorities after the pro forma consolidation has been completed.
Is there a second?
Second?
All in favor?
Aye.
The motion is approved.
The next item on the agenda is Nextera Energy Resources, LLC, filed on May 17, 2018, a request to adjust the eligibility start date for the Bluff Point Wind Facility for entrance into the Maryland Renewable Energy Portfolio Standard Program.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert, behalf of staff. This item addresses the request by Nextera that the Commission adjust the start date for Nextera's Bluff Point Wind Facility to September 1, 2017, from the existing date of January 1, 2018, in connection with the accrual of renewable energy credits, or RECs. If the Commission grants Nextera's request, September 1, 2017 would be the date when Nextera begins earning the RECs. September 2017 is when the facility did begin generating electricity. In determining when the renewable energy facility can start accruing RECs, the regional grid operator, PJM, relies on the standard adopted by the state that granted the renewable energy credits. In Maryland, the standard for a wind facility has been to record a renewable energy facility's eligibility start date beginning on January 1 of the year in which the Commission certifies the facility as a renewable energy facility. Likewise, in response to a request by a Maryland renewable energy facility that PJM add the facility certificate to the GATS account, PJM will add the facility to the GATS account with an effective date of the beginning of the year in which the certificate was issued. Approving Nextera's request would increase the supply of Maryland-eligible RECs, which might have a downward impact on the REC price, but allowing the retroactive RECs would reduce the incentive for renewable energy facilities to apply for certification in a timely manner. And staff is also concerned about the administrative burden that allowing retroactive RECs, such as requested by Nextera. The Commission has approved almost 36,000 renewable energy facilities that have begun operations since January 1, 2016. The vast majority of these facilities that likely were certified in the year in which they began accruing RECs. However, if even a small percentage of these renewable energy facilities applied for retroactive RECs, this could impose a significant administrative burden. Staff also believes there's no compelling reason to change established Commission practice that accrual of RECs begins on January 1 of the year in which the Commission certifies the facility as a renewable energy facility. Therefore, staff recommends that the Commission deny Nextera's request to adjust the eligibility start date for its accrual of RECs.
Thank you, Mr. Albert. I see their request was made on May 15th. There's not a lot of description in here, and the company is not present today. So I do agree with your recommendation. I was just curious, where is the Bluff Wind facility located?
Kevin Mosier, staff, I'll have to check on that again, but I believe it's Iowa.
Thank you.
Follow up on that, Mr. Chairman. Do we know how many of these 36,000 renewable energy facilities are located in the state and how many are located out of the state?
The vast majority are located in the state because the vast majority are solar. You know, of that 36,000, I'd say, you know, there were maybe 100 non-solar. So it's the vast majority of those. We get, again, we probably we probably have a total of about 60,000 solar facilities that have been certified by the Commission. It is, I believe, less than 300 non-solar facilities.
Yeah, it seems a little strange to me because we've had a general understanding that about 75% of the RECs that have been issued in the RPS construct have been issued to out-of-state facilities.
And I think that's certainly true, but I think the difference is, again, you know, in this case, this is one wind facility of 120 megawatts of capacity versus, again, almost all of those systems are residentials with, 5, 10 kilowatts of capacity.
All right, very good. Thank you.
Is there a motion?
Yes, Mr. Chairman, I'd move that we deny the company's request to adjust the eligibility start date for its renewable energy facility.
Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
The next item on the agenda is Blitz Ventures, Inc., filed on July 10, 2018, notification that the company has converted from an LLC to C Corporation.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert, on behalf of staff. This again addresses a notice by Blitz Ventures, which does business as EnergyBot, that it is converted from a limited liability company, an LLC, to a C Corporation, and has changed its names to Blitz Ventures, Inc. Staff has reviewed the filing, and as noted in the comments, the new corporation has yet to update its status with the State Department of Assessments and Taxation, SDAT. Staff recommends the Commission note the name change, direct Blitz to update its registration with SDAT.
Good morning, Chairman and Commissioners. Matt Bonikowski for staff. We did actually receive a late filing. Staff has been in communication with the company regarding registration with SDAT, and the company was able to register this new trade name with SDAT. So Blitz Ventures, Inc. is registered, and the company is in good standing to operate under that trade name in Maryland.
Great, thank you for that update.
And based on that, the Commission recommends that the Commission note the name change.
Thank you.
Question. Can staff describe any obligations that may change for this company when it changes its corporate form to the Commission or under statutory law with regard to being a supplier? Does anything change in reality?
My understanding is that the regulations, their obligations in terms of suppliers and transparency and the type of products they offer and apply across the board. Now, I'll note, that you have a lot of stuff, as you see with the telco reorganizations in the statute dealing with corporate form. Things talk about capital stock and corporations, so business form seems to play a big role there. But in terms of suppliers, I'm not aware of any context where the nature of the business form plays out in terms of obligations.
Okay, thank you, Mr. Albert. I appreciate it.
Is there a motion?
Yes, Mr. Chairman, I move we note the name change.
Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
Next item on the agenda is Astral Energy LLC, filed on August 24, 2018. It's a request to amend its electricity and gas supplier licenses.
Good morning, Chairman and Commissioners. Peter Wilson on behalf of staff. Astral Energy currently holds licenses to operate in Maryland as a market or supplier of both electricity and natural gas, limited to commercial and industrial customers. The company has now requested to amend its licenses to add residential customers. Staff has reviewed the company's request and concluded that Astral meets all requirements to grant the amendment to its license as requested. Astral has no open complaints and is current with Commission assessments. Staff believes the amended licenses will serve to increase competition in the electricity market to the benefit of the public. For these reasons, staff recommends the Commission grant Astral Energy LLC's request to amend its licenses to include provision of electricity and natural gas services to the residential class as requested.
Thank you. Commissioner O'Donnell.
Thank you, Mr. Chairman. A quick question about the complaint history of Astral. I know they have no open complaints, and I see that that's very clearly stated, but was there any discovery of history of complaints? Track record?
Apparently not.
No track record? Okay. Very good. Thank you.
Just one extra question. Do we know if Astral Energy has any experience in the residential market in other jurisdictions?
I don't. No, we don't know that.
Okay. I noticed that we approved them initially, and our review initially was for commercial and industrial classes. And so now they're branching out into another market, which is a little bit different. So,
Right. I think they only requested that at the time, and I don't know why that would be.
Okay.
I mean,
Thank you.
Is there a motion?
Mr. Chairman, I move the commission grant the company's request to amend its electricity and natural gas supplier licenses to include providing electricity and natural gas services to residential customers, and further direct the company to provide marketing and training materials specific to its Maryland operations to the commission staff and the Office of People's Counsel 30 days prior to utilization of the materials in Maryland.
Thank you. Is there a second?
Second?
All in favor?
Aye.
The item is approved.
The next two items will be called together. Item 10 is Titan Gas LLC DBA Titan Gas and Power, filed on August 22nd, 2018, an application for a license to supply electricity or electric generation services in Maryland. And 11 is Titan Gas LLC DBA Titan Gas and Power, filed on August 22nd, 2018, an application for a license to supply natural gas or natural gas services in Maryland.
Peter Wilson again for staff. Pursuant to Public Utilities Articles 7507 and 7603, Titan Gas, doing business as Titan Gas and Power, has filed applications for licenses to operate in Maryland as a supplier marketer of electricity and natural gas in all Maryland service territories, serving all customer classes. Staff has reviewed the applications and has determined that the company meets all requirements to grant authorization as requested. The company has no complaint history in the states where it currently does business, and that would be Pennsylvania, Massachusetts, Ohio, and the District of Columbia, and has provided the bond required by COMAR. Staff has reviewed the company's website and marketing and training materials and finds them satisfactory. For these reasons, staff recommends the Commission grant the company licenses to operate as an electricity and natural gas marketer for all customer classes in all Maryland service territories as requested, and direct the company to notify the Commission within 30 days of any changes to the information in its application.
Thank you, Mr. Wilson. Counsel for Titan Gas and Power.
Mr. Chairman, Commissioners, my name is Philip Sheehan. I'm here on behalf of the Office of People's Counsel.
Sorry.
And the Office of People's Counsel has reviewed both applications, and we support staff's recommendation.
Thank you, Mr. Sheehan. Questions? Seeing none, is there a motion?
Mr. Chairman, for item number 10 and 11, I move we grant the company a license to operate as an electricity supplier and as a natural gas supplier in Maryland for all customer classes and service territories applied for and recommended by staff, and direct the company to file notice with the Commission within 30 days of any changes to the information in the applications.
Is there a second?
Second.
All in favor?
Aye.
Item number 11 is approved. Sorry, item number 10
And 11.
and 11. I'm sorry, Commissioner Richard. Both items for Titan Gas are approved.
The next item on the agenda is Pilot Power Group, Inc., filed on September 6, 2018, an application for a license to supply electricity or electric generation services in Maryland.
Peter Wilson, again for staff. Pursuant to Public Utilities Article 7507, Pilot Power has filed an application for a license to operate as a supplier marketer of electricity, serving only commercial and industrial class customers in all Maryland service territories. Staff has reviewed the application and determined that the company meets all requirements to grant authorization as an electricity marketer as requested. Pilot currently does business in California and has no open customer complaints. Pilot does have a citation from the California Public Utilities Commission, currently stayed on appeal, for failing to meet its 2018 year-ahead resource adequacy obligation, a deficiency which was remedied within 9 days of the citation. The company has submitted the bond required by COMAR, and the company does not currently have training and marketing materials specific for Maryland. Staff has reviewed its website, however, and finds it satisfactory. For these reasons, staff recommends the Commission grant Pilot Power a license to operate as an electricity marketer as requested, and direct the company to provide marketing and training materials specific to Maryland to Commission staff and the Office of People's Counsel 30 days prior to their use in Maryland, and direct the company to notify the Commission within 30 days of any changes to the information in the application.
Thank you. Is there a motion?
Yes, Mr. Chairman. For item number 12, I move that we grant the company a license to operate as an electricity supplier in Maryland for the customer classes and service territories applied for and recommended by staff, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second? All in favor? Aye. The motion is approved.
Item number 13 is Transparency Energy Services, LLC, filed on September 18, 2018, an application for a license to supply electricity or electric generation services in the state of Maryland.
This is the application of Transparency Energy Services, LLC, for a license to operate as an electricity broker and aggregator in Maryland. The company seeks to serve commercial and industrial customers in the service territories of all 4 investor-owned electric utilities. The applicable law is the same as for the preceding items. The company has filed the required $10,000 bond to meet the financial integrity requirements and has met the other requirements as well. The company does not yet have Maryland-specific training materials. Staff recommends that the Commission grant the company a license to operate as an electricity supplier in Maryland, limited to broker and aggregator services. Additionally, the company should be directed to provide marketing and training materials specific to its Maryland operations through the Commission staff 30 days prior to using those materials in Maryland. Finally, staff recommends that the Commission direct the company to notify the Commission within 30 days of any changes to the information upon which the Commission relied in granting this license.
Thank you. Is there a motion?
I have
Oh, sorry.
I just had,
Langton.
I'm sorry, just one quick question. I noted that the company didn't apply to offer broker services in Choptank and Smeko service territory. Did they provide any rationale for that, any reason?
Not that I'm aware of, but I'll let Mr. Bonikowski speak to that.
Good morning, Chairman and Commissioners. Matt Bonikowski for staff. No, they did not, but we did verify that that was not a clerical error. They do not intend to operate in those territories.
Okay. Thank you.
So I had a question. Your comments say that they have a significant experience in the energy industry, but that they're newly formed and not operating as a supplier. Can you just give us a little more information about the significant experience in the energy industry?
Yes, that's based on the resume of the owner, which was included in the application. Just trying to flip to it. From memory, he was an employee for several years at a utility and was engaged in sales and marketing. That was the basis for our conclusion that the company does have at least a foundation of experience in this industry.
And was the PJM membership included?
Because the application is for broker and aggregator
Broker
services.
only? There now need to be a...
Correct.
Okay. Ready for a motion, Mr. Chairman?
Thank you.
Mr. Chairman, I move we grant the company a license to operate as an electricity supplier in Maryland, limited to broker and aggregator services for the customer classes and service territories applied for and recommended by staff. Direct the company to provide marketing and training materials specific to its Maryland operations to the commission staff 30 days prior to utilization of the materials in Maryland. And direct the company to file notice with the commission within 30 days of any changes to the information in the application.
Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
Items 14 and 15 can be taken together. Each of the filings is by the Eastern Utilities Commission. Each was filed on September 12th. Item 14 is the company's proposal to modify its time of reconnection periods for customers, and as well as in item 15.
Item numbers 14 and 15 are respectively electricity and gas tariff revisions filed by the Eastern Utilities Commission. Eastern is modifying its tariffs to reduce the evening hours during which it will reconnect gas or electric service for customers who have been disconnected. Under the current tariff, the company performs reconnections from 8 a.m. to 4 p.m. Monday through Fridays, excluding company holidays, for a charge of $35, and from 4 p.m. to 11 p.m. Monday through Friday, weekends, and during company holidays for a charge of $45. The proposed revision would shorten the later reconnection window to 4 p.m. to 7 p.m. Easton is proposing this change for reasons related to worker safety. As noted in staff's comments, over the last 3 years, less than 5% of electricity reconnections were performed after 7 p.m., and no gas reconnections were performed after 7. Staff recommends the Commission accept the tariff pages for filing and direct the company to file a clean copy of the affected tariff pages with an effective date of October 15, 2018.
Thank you. Counsel for Easton.
Jim Crowley, Eastern Utilities, Manager of Gas, Meter, and Corporate Safety. No comments or questions.
Thank you. Mr. Crowley, just reading the application, this makes some sense to me. Although, do your employees who actually do the reconnection at night receive cash from the customers?
No, we stopped the cash policy several years ago. We do take personal checks as well as money orders for payments for past due delinquent utility accounts.
Okay. Thank you. Any questions?
Just briefly, do you have does the company have a notification or communication plan to customers about this change in policy?
Yes, we do. We're in the process of putting that together, subsequent to Commission's decision to allow our customers to know the change in policy. Our customer service reps and our nighttime control operators are going to be well versed in the change as well, and so we are going to get ahead of it to make sure our customers understand the change in policy.
Great, thank you.
Is there a motion?
Mr. Chairman, I move the commission for both items 14 and 15 accept the tariff revisions for filing and direct the company to file clean copies of the revised tariff pages with an effective date of October 15th, 2018.
Is there a second?
Second.
All in favor?
Aye.
The motion for both items 14 and 15 are approved. Thank you.
The last item on the agenda is number 16, Community Energy Solar LLC, filed on July 19, 2018, request for a waiver from operational deadline.
Good morning, Mr. Chairman, Commissioners, Annette Garofalo on behalf of Commission staff. Community Energy Solar LLC and its affiliated subscriber organization, Rockdale Solar LLC, are seeking a waiver under Comar 20620104 of the operation deadline for completing its community solar generating system, which is located in Washington County. The waiver requested is for a 6-month period after the expiration of the 8-month period allowed under Comar 20620304C1. As good cause for granting the waiver, Community Energy states that the Commission did not approve a contract disclosure form as described in Comar 206206 until recently. Applicant has not had any significant zoning or legal issues, and its 2-megawatt facility is supported notify Potomac Edison. At this point, the contract disclosure form has been approved for approximately 6 months. Staff does not believe its former lack of availability constitutes good cause on which a waiver should be based. The date of its availability would in fact render meaningless showing of good cause for any future year one applicant, because all could claim the contract disclosure form had not been available. With a 6-month extension from PE, Community Energy's project deadline will be extended to early February 2019. As with previous waiver applicants, Community Energy is concerned about the possible effects of a winter construction period, and staff recommends the Commission grant Community Energy LLC a waiver of COMAR 20-620304C until June 1, 2019, contingent upon Community Energy's payment to the Potomac Edison Company of the amount required under COMAR 20-620304C1 to retain its place in Potomac Edison's queue.
Thank you, Ms. Garofalo. Mr. Bugelmans.
Good morning, Mr. Chairman, Commissioners. David Bugelmans on behalf of Community Energy. We thank staff for its support of a extension for these projects. We've crunched the numbers, and what the project needs to reach commercial operations is an August 1st extension, which is 2 months in addition to what staff has recommended. The issue is, as staff counsel indicated, is that construction would occur at this point during winter, and winter conditions could push the construction schedule out, which would force us to come back and request a further extension. So we think in this case 6 months would be appropriate. I'm happy to answer any questions from the Commission. Thank you.
Mr. Bugelmans, looking at your filing dated July 19th, did you request an August 1?
I believe it was close, Your Honor. We requested a 6-month extension, and I believe the original deadline upon payment of the deposit for an additional 6 months was early February. So I believe August 1st is a bit shorter, but only by a week or so.
Your client stated that they expect to commence construction by early October, which is now. What's the status of construction?
My understanding is that they could issue a notice to proceed with sort of the final prep activities next week. I actually have a chart here. Let me take a look. They would need to complete final design and engineering, which they've essentially withheld that step pending resolution of this request. That would end by the end of December, and then construction could begin February, March. So again, that pushes it out to the middle of winter.
Construction won't begin until next year, is what you're saying?
Correct, Your Honor.
Mr. Bugelmans, I'm just a little confused. Just a few months ago, I guess they thought they were in a position to break ground in states here early October. Maybe I'm missing something, but what was the reason for the delay in not issuing the notice to proceed?
I understand the lack of clarity in that sentence, and I think actually staff mentioned that in their buck sheet. That was referring to sort of when they could proceed, but recognizing winter construction conditions, we requested the 6-month extension. So we were essentially recognizing that, yes, they could conceivably begin, but we need the additional time to be able to complete construction given winter.
Does staff have anything to add or respond to Mr. Bugelmans?
Well, so staff only knows about these things, what is communicated in the application. Sometimes Mr. Bugelmans gives us an update. We are trying to be flexible and to give them time to build. They say it's only a 3-month period. The time with the extension from PE would take them to February 6th. That is the middle of the winter. And so while we think June 1 would be sufficient time, we recognize that the applicant may see that differently. What we're trying to do when we recommend June 1 is we're trying to keep people in a line so that there's some consistency within the applicants. However, you have approved, I think, an August 1. You've approved a July 1 for sure, and you may well have approved an August 1 date.
Thank you. Commissioner O'Donnell?
Yeah, first for staff, we're seeing a fairly regular stream of these extension requests. How many of them are in the queue to come to us?
I can't answer that. I can say that there are 2 on my desk, and Mr. Bugelman's told me he had sent me one by email, but I think it's a follow-up to something you've already seen.
Yeah, I mean, this is a pilot, right? Community solar is a pilot, and it's a little frustrating because these extension requests kind of frustrate the corners of the outline of the pilot, and it's frustrating because we have to report on these things in our reports to the General Assembly, and we have to evaluate the efficacy of this and what went right and what went wrong, and these constant requests for extension seem to skew that, in my opinion, a little bit, Mr. Chairman. This effectively, the company's request will take this to a 2-year construction period.
That's right.
So the way the construct is set up is you have 12 months to become operational, and with an extension available for another 6 months if you pay the premium to maintain your queue position. And this is 6 months beyond that, so it's 2 years construction. I watched this tower come up on this corner over here, and they didn't stop construction in the wintertime, I guarantee you. They were constructing. And I'm not sure the wintertime, I understand the ground gets hard in the wintertime, but we can overcome that. I believe we have the technology to do that. I'm not sure what else stops us in the wintertime from construction, other than maybe a week delay here or a week delay there, but 6 months, having a hard time. It's not passing my common sense test, Mr. Chairman.
Thank you.
Does the company want to comment on that, or staff?
I could provide some additional detail related to the winter construction. The issue really is with these projects, they're over a large area, and really the danger is it's with stormwater and sediment control violations that could occur during construction. Basically, if you were to rush this during winter months where there's rain, where there's snow, you could actually create a situation where there's significant violations of those requirements with runoff, and that could lead to, in some cases, millions of dollars in violations from MDE. So that's really the concern. It's really the nature of these projects and the fact that these are on essentially green fields, and just sort of the logistics of that type of construction is a bit different than...
But Mr. Bugelman, didn't your clients commit to that when they committed to the program to receive the benefits of the program?
I think a common thread with all these projects, Your Honor, is the deadlines. I don't think it was intentional, but the deadlines came out where even with the 6-month extension, it's essentially right in the middle of winter. And I think a lot of the tension you see is because of that. It's really the concern of, they need to finish this thing and commence operations when there's significant variability. And I think that's really the issue. And I think you can see with all these developers, they didn't foresee that until 6 months ago when these requests started to be made. So I think it was an unforeseen issue across the entire industry.
Yeah, I appreciate that. The reason the time constraints are put in there, of course, is so that people don't just throw their hat in the ring, get in the queue, and then lock on and displace somebody else from getting in the program. And so that's kind of a general concern that I have, and it's why the program was structured the way it was structured. So I don't know what we can do about it at this point. I'm prepared to support this based on the recommendation of staff, but only to the level of the recommendation of staff, because I'm not sure I can support anything beyond that. That's just where I'm at, Mr. Chairman.
Commissioner Herman, thank you.
So, Ms. Garofalo, I'm trying to make sure we get this waiver correct. Are we waiving 2062-0304C? Because 0304C, I thought, was where you end up paying the additional deposit of $50 per kW for 6 months, and that the 2062-0104 is good cause shown. So we're not. Are we waiving 04C? Because I thought we wanted them to pay the 6 months.
We do want them to
We want
pay
them to
that.
pay the 6 months. So
They-
we're not waiving that one. We're doing, if we were to grant the waiver, we would be an additional 6 months beyond that
Correct.
6 months under 2062-0104.
Correct.
Okay. I just wanted to make sure that I think your original document said we were waiving 04C, but we're not, right?
If it said that, then that was correct. What we could not be sure they had paid Potomac Edison the amount that was required. We wanted them to get that 6 months and pay for that, and then they're asking for additional time, and we're recommending that they get additional time until June 1.
Right, but your request was a waiver of 620304C contingent upon the payment. But why do we have to waive that? That's what I'm asking.
You don't have to do anything to take them up to 18 months.
Right.
And they're asking for a waiver beyond of that time period.
Under
Beyond
04C1.
2062-0304C.
But-
there it is. There's the mistake. Yes.
Yeah,
Yes.
that's where I'm coming.
Exactly right. No, that's
So it's not 04C1, it is 0104.
0104, correct.
Okay, I just want to make sure we waive the right thing. Mr. Bugelman, are you?
I'm following, Your Honor. I think you're
following?
correct.
Okay. So we're not waiving 04C, and have you made the payments?
The payment has not been made, and Potomac Edison hasn't required payment until this request has been heard.
Okay.
But the company's prepared to make the deposit.
Okay. So we could grant the waiver under 620104 contingent upon the payment of the fees. Would that be what we should be doing here?
You could.
Since the fees haven't been paid.
Correct. As long as you, I would respectfully request that you just not make it for the reason of the timing of the contract disclosure form, because that applies to everybody.
You're suggesting that the commission should just waive it for good cause shown.
Well, I think you'll have to find, we attempted in what they said to find good cause, and that's why we talked about the winter. But if you waive it for what they offered as good cause, which is the fact that the contract disclosure form was approved in April, that applies to everybody who is in the queue.
Where are we stipulating this? I'm going to request that Commissioner Herman make the motion when it comes time. Other commissioners, any questions of counsel for either side?
I just had one. I wanted to make sure I understood. So, PE is supportive of this request,
Correct.
but the deposit hasn't been made yet because
Correct.
they wanted you to present here first.
Correct, Your Honor.
Did they want to get an approval from us before you paid the deposit?
I think that's illogical. I think that's what the thinking is. And while it wasn't explicitly discussed, I think in some of the other waiver requests, the utilities had, and I'm kind of going off of memory, but I think at least for one of them, the utility hadn't required payment until the request had been heard. The thinking really is, if they were to pay prior to having the request heard, then it would just be forfeited if the request wasn't granted, essentially. So I think that's what the thinking is on that.
So the expectation then is that they know up front you won't make the 6 months.
Correct.
All right. And just generically from our staff, since this pilot has been moving forward, how many companies do we have now that are prepared to offer, allow consumers to enroll and purchase solar, become subscribers of the program?
How many have completed?
Right. How many have completed forward? Do we have anybody that's...
I don't think we know.
Okay.
We don't think there are any large, this is a 2-megawatt facility. I
Right.
don't think there are any of that size that are completed.
All right, thank you.
Yeah, just a question. Now that the contract disclosure form is available, has the company begun to solicit subscribers?
The company has begun, Your Honor.
Okay,
They've teamed up with Neighborhood Sun, which is sort of the customer-facing side of their operations, and they're beginning to market.
Okay, so that activity has begun. And then I also just wanted to find out, I mean, I guess there's a question now between, whether we approve the waiver through June 1st or August 1st. After that date, do I understand correctly that you would forfeit the waiver, the company would forfeit the waiver if they were not operating?
Beyond August 1st, or?
Well, depending on which date we choose, if the company does not perform by the date that we, up to the date we waive,
right,
is the deposit forfeited?
So yes, that's correct. I mean, if the project does not become operational by whatever date the commission decides on, it would waive the deposit. That's the point of the deposit. It's supposed to ensure that there's skin in the game, so they move forward.
Well, I just wanted to find out, since we have this question before us, whether we go with the date you're requesting, August 1st or June 1st. Is the company willing to proceed if we go with June 1st, or is the risk of losing the deposit something that would, again, make the company maybe withdraw?
Right. I think it would be very difficult. I obviously, we discussed that, and I think it would be very, very tough. I think it would be better than not getting August 1st. But it does put things into jeopardy. And really the issue is that, these 2 months, it allows for contingencies and issues that pop up. And if you have a scenario where the project could be kicked out of the program because they don't meet the deadline, that creates issues with financing. That's something we saw with the other waiver requests. So sort of that additional wiggle room, with a few months is necessary. So I think June 1st could work, and they could make it work, but August 1st is much more feasible and much more likely to work for them.
Okay, but to my question, so the company would move forward if we select June 1st, or is that a risk the company you do not believe is willing to take?
I think it's a risk that they could take. I don't know definitively if they'll move forward. I think they would have to do some additional homework on that. But I have been told that that's better than August 1st. It's something that they could make work.
Okay, thank you.
Any other questions? Commissioner Linton.
I'm sorry, just one follow-up to Commissioner Richards' question. You noted earlier that you've already had you've started the process for enrolling subscribers. What start date has the company been telling those subscribers that the program will begin?
I'm not aware, Your Honor. I could follow up on that. I know, having looked at these types of projects, oftentimes, the start date's projected, and there's often notice given, but it's often not firm. I think to account for variability with construction timelines.
Okay. Thank you. I guess you could follow up with the staff.
Okay.
Thank you.
So, also to follow up on Commissioner Richard, I think that if the commission granted June 1st, Ms. Garofalo, couldn't the company come back and say, oh my gosh, we hit bedrock and, it took 3 times as long to drill through it? It's a ridiculous, scenario, but I'm just giving a hypothetical that something happened during construction that caused a delay. Would the company be able to come back and request a further waiver?
There's nothing in the regulations that say you can only apply for a waiver once, only that the waiver has to be granted for good cause.
Okay, thank you very much.
Thank you. This is obviously a tough situation. We've seen, at least I've seen in my short time here, probably about a dozen of these extensions for participation in the CSEG program. However, we need to keep the applicants' feet to the fire and keep these moving. For that reason, and also noting the concerns that were articulated by Commissioner O'Donnell, I support the staff's recommendation of June 1st without prejudice for the applicant returning if there is a problem as you approach this summer. Other commissioners, or do we have a motion? And I would ask that Commissioner Herman make the motion.
All right, and I ask my colleagues to correct me if I'm wrong, or if I'm not expressing what we want to accomplish. I move that we grant Community Energy Solar, Inc. a waiver of COMAR 2062-0104 until January 2019, contingent upon Community Energy Solar, Inc.'s payment.
You mean June?
Did I say June?
January.
Oh, I'm sorry. I read June. Let me start again.
Thank you.
I move we grant Community Energy Solar, Inc. a waiver of COMAR 2062-0104 until June 1st, 2019, contingent upon Community Energy Solar, Inc.'s payment to the Potomac Edison Company of the amount required under COMAR 2062-0304C1 to retain its place in the Potomac Edison Company's queue.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
Thank you.
Thank you. Seeing no additional business before the commission, this meeting is adjourned.